Hello everyone, my name is Louise Atlantang and I was a delegate of both the Enbridge Line 9 hearings. And I heard the verdict was in favor of Enbridge and saying that the National Energy Board fulfilled the duty of the Crown to consult with First Nations. And I'm here to debunk that entire myth because as a participant we were never informed that the NEB process would ever perform such a function. I attended the Supreme Court case myself, and I witnessed as the National Energy Board admitted the fact they did not know they were doing the Crown duty at the time, and none of the delegates, including myself, were reasonably informed that this was fulfilling the Crown duty to consult. In fact, the treaty issue concern goes right back to the very first hearing that I witnessed in London, Ontario in May 2012. Where I witnessed the beginning of the National Energy Board hearing. It started off with protests. A mic check was done. There was people all around the room who stood up and opposed this line. Ruby and Floyd Montour from Six Nations were there, and as elders who defend the treaty, they were not reasonably informed of this hearing process, nor did they even know there was a pipe. We had a lot of people upset about the fact that they were not reasonably informed about these hearings. And there was a girl who did her research on the different communities, talking to neighbors to ask if they knew there was a pipe in their backyard, and none of them had known it. This pipeline goes right through downtown Toronto. I was at the second NEB hearing when I heard the Toronto representative state that the fire department was unaware that Line 9 goes underneath their fire station. Okay? Toronto was not informed of the National Energy Board process until Eco-Justice actually approached them. It wasn't Enbridge who took the duty to do that. Toronto wanted to secure the data from Enbridge as to where the pipeline was, and Enbridge refused to give it. And the City of Toronto said, well, you don't know where all of our sewers are. If there's a spill, it could hit Lake Ontario really fast if it goes through the sewer system. We need this information. I witnessed students from York University go to the hearing because the pipe crosses in front of York University, and they wanted to know if there's an oil spill around the university, would Enbridge be willing to compensate all the students' tuition? This crazy pipeline goes over a subway station, and if that happens, what happens with the liability risks? During the first Line 9 hearing, I asked Enbridge how much the pipe is insured for, and I asked them, how will we compensate the farmers of the Grand River watershed if the aquifers are contaminated? Because we get 75% of our groundwater in Waterloo region from our wells. How will they even clean up a spill if it goes into the aquifer system that feeds our interconnected well system? And I didn't get any response back. I gave a written question to Enbridge saying, are you even testing the wells near the pipeline for benzene? Enbridge's written response to me was that a spill of benzene is highly unlikely, and that was it. They never went into detail about how they'll monitor for these spills or monitor for the safety of the line in regards to our water supply. The pipeline crosses the Grand River, which is 25% of Waterloo Region's water supply and 100% for folks downstream in Paris and Brantford, Six Nations. I asked Enbridge, how much is the line insured for? They refused to answer. Okay? So this is the economic risks that we're all facing from this pipe. They have no regard for the industries and the communities dependent on these water supply. Downtown Toronto, okay, like Enbridge, even if Enbridge has a $1 million liability, it's not going to cover for property damage if the spill ruptures in Toronto. A single property can refute that, a single house, okay? But no, there's no regard for the numbers. There's no regard for the real safety issues. Now, when I went to the Line 9 hearings, I presented the fact that these valves were placed all on the wrong side of the river because the pipe had gone from Montreal to Sarnia, and now they want to reverse the flow the other way. The pipe in the direction of the flow is all on the wrong side of the river. Okay, so even if there's a rupture in the pipe, you can't stop the flow from pouring in. And then the way Line 9 was done, it preceded the Navigable Waters Act. So that means that the pipe's valves are basically 12 kilometers apart. Okay, so even with all valves closed, there's still a possible 12 kilometers worth of oil that could discharge in any major waterway where the line crosses because it doesn't have the dual valves. Now, around the Grand River watershed here, we had the valve placed, the one valve placed. Not only was it on the wrong side of the river, it was underwater. Because the pipes were placed in the 1970s, it didn't have regard for the growth upstream and the fact that the Grand River widened with the excess stormwater runoff. So every spring, this manual valve was underwater. And so these concerns were raised, and Enbridge has since fixed that particular issue. But I went to the National Energy Board to ask about the over 100 other crossings of Navigable Waters Act that haven't got those two valves. Okay? We have a lot of issues. Enbridge only fixed about 14 of the valves, according to the news reports I read. But there's still over 100 valves that don't have the dual valve systems. And that upset me a great deal. And I'm worried about the communities involved. I'm worried about the fisheries. I'm worried about the Great Lakes. I'm worried about where Enbridge Line 9 could leak and perhaps get into the water intake for the nuclear power plants. I actually went to the Darlington hearings about the refurbishment that they want to do at Darlington, and I asked the Canadian Nuclear Safety Regulator, I said, are you in discussion with Enbridge as to who's going to foot the bill if there's a Line 9 rupture? Because if it goes into the intake, we're talking about a massive power shutdown. Who's going to pay the bill? Will it be the Canadian Nuclear Regulator? Will it be the provider of the nuclear power? Will it be Enbridge? Who's liable? They never answered me. I don't even think they thought of the question. So I really have grave concerns over the liability risks associated with this aging pipeline. Now, the engineering, in my view, was absolute rubbish. We saw hydrostatic testing take place on the pipeline when the ownership was being changed. They transferred the asset, including Line 9, from Enbridge Pipeline Incorporated to Enbridge Income Fund Holding. So I contacted the National Energy Board for the CPCN certificate of ownership to see who owned the pipe. When I received the one for Line 9, the ownership wasn't even bound to Enbridge. It was bound to Interprovincial Pipeline Incorporated. And Interprovincial Pipeline Incorporated no longer exists. So I'm wondering if Enbridge even has a legal CPCN certificate for the totality of Line 9. They transferred the asset from Enbridge Pipeline Incorporated to Enbridge Income Fund Holdings Limited in the U.S. That was a U.S.-based firm at the time. It switched hands without complying with Section 71 of the National Energy Board Act, which demands that they ask the National Energy Board whether or not this is in the public interest. The National Energy Board has to approve these transfer of assets before it takes place. But for some odd reason, it never happened with Line 9, and I'm really curious about that. It happened at the time the hydrostatic testings were taking place in Gananoque. So I don't even know if the guys doing the work had a legal permit or not to do that work. And Enbridge right now is applying for all kinds of permits all up and down the line for water taking so that they can do integrity dig. But I don't see any valid CPCN permit with the name Enbridge Pipeline Incorporated on it or the name Enbridge Income Fund Holding Limited on it. The only one that I did see was a very curious permit indeed. Because after the Line 9 hearing took place, there was another hearing at the National Energy Board that allowed the sale of a portion of Line 9, the end portion in Montreal, to go to the company Valero. They sold that little bit of the end of Line 9. Now get a load of this. The first National Energy Board hearing allowed the approval of the totality of the line, saying that it would be reasonable to allow oil to flow through from one end to the other, basically, right? But about 6 months later, they allowed the end portion sale to Valero because the pipe wasn't up to code. The pipe had only epoxy covering, and it had been leaky. So they allowed the sale to Valero to be handled by them instead. And they were going to basically replace this section of line. Well, if the end pipe of Line 9 was not up to code, and yet the NEB said the totality of the Line 9 was to code, which is it? Because it's like sucking and blowing at the same time here. We're hearing two different messages from the same board, two different verdicts that are conflicting each other from the National Energy Board. The one regards Line 9 approval, the other one regards the Valero sale of Line 9 to Valero. So, which is it? So during this Supreme Court case, we heard that the National Energy Board performed the duty of the Crown, therefore Crown consultation is not needed. But what they failed to tell you is the rest of the story, and I'll give it to you. Now, during the Line 9 hearings, it was Amanda Lickers went up and presented evidence that she secured from Enbridge. It was part of the Q&A process of when we can ask Enbridge some questions and they answer. She asked, did Enbridge review any treaties? Enbridge wrote back, they didn't review a single treaty. Well, this, in my view, is perjury because it violates what I know Mayan Gun Henry did with Enbridge. Mayan Gun Henry met with Enbridge staff with the two-row wampum. He spoke to them and described the treaty with them. He has photographs and videos of this process, and they gave him a ring from the Kalamazoo pipeline in exchange. And that occurred before the second Line 9 hearing. So while Enbridge states they are unaware of any of the treaties of the 18 First Nation territory that they cross, they're full of it because they were obviously presented with the two-row wampum in this process, and they were informed. So we're getting two different stories here, and in my view, it's perjury. So the National Energy Board was given the duty to perform the Crown consultation, but they were unaware of that at the time of the hearing. That MOU only came well after the hearing was completed, and that's a very bizarre situation. Because I went to the Supreme Court case and I watched as the NEB admitted to the board that they were not prior informed that they were performing the duty of the Crown until after the fact. And as a delegate, I was not informed. None of the First Nations communities were informed that this was the case. It was a joke. But not only that, there was other Crown agencies have found the National Energy Board to be deficient. The Federal Environmental Commissioner of Canada have reviewed the National Energy Board and found their work either missing or it was incomplete. They had no ability to monitor for compliance of their line to make sure that these things were safe. And they only had the data in 50% of the cases that they monitored that was showing a sufficient system. So this was woefully lacking. And then later on, Trudeau created a board to monitor the NEB and assess their performance, and they found the NEB should be scrapped. That was their actual verdict, is that the NEB has been doing an insufficient job. They lost the trust of the public. They should be abolished and turned into two different agencies. So there you go. We have two separate Crown agencies that are saying that the NEB is insufficient, and then we have this board verdict from the Supreme Court that says the Supreme Court believes the NEB can handle it. Well, how does that work? Because it doesn't look like the NEB can handle their current tasks, let alone the duty of Crown consultation. Okay? But going deeper still, I want to say that as a First Nations in Canada, we have a protocol and a procedure to follow. We have to abide by rule of law. We are nations bound by treaty law, and we can't just hand that over to a non-nation to handle. The National Energy Board is not a national agency. They are a creature of the Crown, but they are not the Crown itself. So for us to deal with the creature of the Crown, which means an invention of it, we cannot reasonably meet with our legal obligations for a meaningful process. It's illegal for us to do that. We can't just hand these rights over. It's unreasonable to expect that we would. Many of our treaties were ratified directly with the UK. It had nothing to do with Canada. Our treaties predate Canada. Okay, and my family became a nation in 1610. The Mi'kmaq people signed the Vatican Concordat. That's a nation-to-nation agreement. You know, meanwhile, Canada tries to claim that it can step in as a nation. Well, why is the Canada registered under the US SEC as a corporation? Corporations don't have the legal right to handle treaty. Learn the law. We have to abide by laws as First Nations people. We're not going to break law to make Canada have an easier time here. We really have to get to the bottom of what is Canada's legal power here, because it looks like they're the ones violating law, not us. First Nations are fighting for compliance to law. That's all we're doing. We're trying to go by the book. We're trying to go by the rules we're given. And the way that the Supreme Court ruled, it makes me question how legal this ruling actually is. Okay, we know our history. Does Canada? Do Canadians?